Excellent. Thanks very much for inviting me. Thanks to ESHG and MPAG for this session. So I am right now doing my PhD in law at the University of Edinburgh, which is a bit strange sometimes when I'm saying I'm doing a doctorate in law. They say, well, you've already done law. What more is there to do? But I guess I'm taking a more theoretical investigation now of issues as it relates to health research, including genomic research. And I'm lucky because my supervisor is one of the deans of genetic privacy, Graham Laurie, who literally wrote the book about a decade ago on genetic privacy. So before I start, I just want to be clear and upfront about some of the things I'm going to be talking about relate to the Global Alliance for Genomics and Health, and I'm still involved with them. I used to coordinate the Regulatory and Ethics Working Group, which is developing policy-oriented solutions, I think, in addressing some of the issues that we heard from Yaniv. And I'm also a member of the ICGC's Identifiability and Privacy subgroup, so I just want to make that clear. The goal of this presentation is to talk both about the general growth of international data sharing, of which most of you are well familiar with, some of the challenges that we've heard about as it relates to privacy and confidentiality and data protection, and then the role of policy, which picks up on Yaniv's kind of concluding part of his presentation, to address some of these challenges. And I want to focus in particular on the work of the Global Alliance, because that's what I'm most familiar with. And then to conclude with a parting thought about the importance of sustaining privacy as a fundamental value in research, and to show that there's not an irreconcilable tension between privacy and data sharing. So I just pulled a couple of these images coming from the last year. I mean, I don't need to make the point that there's been a complete growth in the literature about genomic data sharing, clinical data sharing, aspects of it. And of course, we now speak in the genomic world of a genome commons. We can't speak about that when it comes to clinical research or clinical trials, but certainly there's been a push in the clinical trial space as well with the IOM report a couple of years ago in the US and other reports. We see this with the clinical trials regulation in the EU, pushing towards greater sharing of data. And there are multiple reasons. These were just a few of the reasons that I think that come to mind as to why we should share data. And I think most of these are probably quite well known to you, but it just illustrates the point that there are numerous reasons as to the benefits of sharing data. So those are the kind of scientific reasons, let's say. I mean, you could also say that it's required by funders, and there's cultural reasons as well, but there are certainly scientific reasons. I think we also should acknowledge that international law encourages researchers and others to share data, make their data available, and we can even push this back to the 1948 Universal Declaration of Human Rights, but carrying all the way through. So we see, for example, the International Declaration on Human Genetic Data from 2003. This is one of the declarations that is most pertinent to this field. It makes very clear that there's an importance of encouraging the sharing, the free circulation of data, because it benefits a variety of people and not just science. And then we see also from the OECD in their 2007 report, alluding to the fact that because often funding is public, there's a duty behind it to encourage the greater sharing. And then, of course, if we focus down onto the kind of genomics world, we see all the way back from the 1993 NIH Department of Energy guidelines encouraging within 6 months of generation the publication of genomic data, that then moved to 24 hours with sequence assemblies of greater than 1,000 base pairs, to Fort Lauderdale principles, which encouraged beyond just genomic data, Amsterdam principles to proteomics, the Toronto Statement, all the way through 2011 with public health research funding. And this was a joint statement by many of the major biomedical funders around the world, speaking about the importance of equitable, ethical, and efficient ways to make data available. So maybe we should back up a little bit. I realize this is an educational session. It's important to kind of focus on terms, and of course lawyers like words and defining words. So we can say, what exactly do we mean by data sharing? There's different ways we can define it. You can say it's the intentional making available of data to others, and this can be through individuals or groups, but it's just this notion of intentional making available of data, let's say. So in the Global Alliance, in our privacy and security policy, this was a definition that we put forward. We wanted to stress that it's not just a point A to B transfer, right? That's simply even viewing on a screen. It could be a notion of sharing of data. And then, of course, we know that it's increasingly encouraged by funders to make data available, and there's different databases that are quite well known. This is a bit of an old slide. The point is not to read it, but just this came out in 2008 in PLOS Medicine, and it's a really, I think, useful kind of taxonomy of the different ways of thinking about what data sharing means. And I encourage people, if they're interested, to look at that link from 2008. Another way to envision what we mean by data sharing is this kind of heuristic breakdown between how, why, and when. And so if we think about how data sharing is done, we can say, well, it could be some sort of ad hoc arrangement between researchers. It could be pooling databases into some sort of network and a community interest notion, and of course the classic deposition into some sort of centralized or distributed database. We also can talk about different types of operations performed on data, or different types of operations performed around access. So we can have, as we heard, open or restricted data, and we can also have open and restricted access. So for example, if we have very identifiable data where very little operations have been performed on them, we might have very heightened access restrictions. So there's different ways of envisioning what we mean by open and restricted. And then of course the question arises as to when we should be sharing data. Is it immediate? Is it only after IP has been secured? Or there's been some sort of publication from the data? There's often the classic publication timeline lags, which can vary between 3 months, 6 months, 9 months, depending on the policy that's put forward. But it's another fundamental question to ask: when exactly do we share data? We could also ask, why has there been such a growth? And certainly we can point to technological advances with cloud computing, next generation sequencing, greater investments and acknowledgement to the importance of sustaining big term projects, international consortia, the greater requirements being put out by funders, journals, and institutions. Of course, the growth of patient-led initiatives to encourage the sharing of the data with projects like Patients Like Me or Free the Data. And then, of course, because the science demands it. Because for the statistical power needed to try to make correlations between common and rare diseases, you need thousands, if not millions, of genomes to do it. So if this is kind of setting the high level about data sharing, let's drill down a little bit into privacy and what we mean by it. So there's not an irreconcilable tension between privacy and data sharing. But we acknowledge that, of course, in law and policy and other sorts of regulations, that there are restrictions on what you can do with data, particularly with the making it available to others. So we can call it sharing, or we can call it processing or transfer, exchange. But the notion of doing things with data, there are restrictions around what you can do with it. And so this is a very interesting quote I find from Sheila Jasanoff, who's a science and technology studies scholar at Harvard. But she makes the point that openness is a treasured attribute, but we have to be very careful with what we mean by it. We have to purposely cultivate it and judiciously deploy it in order to preserve it. So before I get a little bit into the privacy concerns, we should acknowledge also that there are various barriers to making data widely available to others, not just the privacy concerns. And that there's been a lot of studies that show, despite the fact that there's a desire to make one's data available, often there are various barriers in the way. And these could be technical barriers, things like data non-compatibility or coding heterogeneity. Often it could be a lack of data policy harmonization. Different institutions have different policies and they conflict with one another. Even the same institution can have 2 different data sharing policies, and it creates an absolute maze of confusion. There are kind of operational challenges, the lack of structural support. Is there enough funding available to sustain the project, to curate the data over a long period of time? And then, of course, there are more cultural and behavioral considerations as well. So there are concerns, we're well aware of them, about equity in the sharing. So this relates in particular to international consortia and projects that go into lower middle income countries. Is there a proper reciprocity, a notion of solidarity in the effort to make data available? And then, of course, there might be a lack of incentives built in. This can be both in terms of career advancement at institutions, but also journals as well. Now, that's a technical and let's say, cultural consideration, but let's keep going forward now into legal and ethical considerations. There are concerns absolutely about intellectual property. Can you make use of data if there are patents on it or copyright restrictions? There are concerns, as we've seen in the last year in the New England Journal of Medicine, about secondary data users as parasites. And then, of course, this general concern about the impact that data sharing might have on early career researchers who are a little bit tense about sharing their data when it could impact on their advancement. Okay, but now let's really focus on privacy. I think, again, it's important to acknowledge or try to define what we mean by privacy, and there are different dimensions of privacy. Very famously, in 1997, in an early book on genetic privacy that was written or edited by Mark Rothstein, who's at the University of Louisville, Anita Allen, a very famous privacy law scholar, said there are 4 dimensions of privacy. There is the informational dimension, there's the decisional dimension, there is the proprietary dimension, and there's the kind of decisional dimension. I think we should be very much clear that we're focusing on the informational dimension here. And in particular, you can say it's maybe something about controlled access. I think some, including Graham Laurie, want to move away from this notion of control because not every loss of control is a loss of privacy. So we should be focusing more about this kind of state of affairs where information relating to a person is in a state of non-access, or if we want to concede a little bit the notion of control to a degree, let's say curtailed access. And we know that it's valuable both for instrumental and intrinsic reasons, right? It enables people to flourish in developing relationships of their choosing. And it's also grounded in classic values of dignity, autonomy, and integrity. Now, we can debate whether or not genomic data are exceptional or different from other types of data, but we have to acknowledge that in data protection regulation, they are. And we see this in the data protection regulation that was just finally published on May 5th in the official journal of the European Union, which considers genetic data, biometric data, other types of data concerning health as not so-called sensitive data, but data of heightened restriction with what you can do with them. So then let's having this as our kind of backdrop, let's acknowledge a few points then. So genetic data has to be processed in ways that respect the fundamental rights and interests of individuals in society as are reflected in regulation and policy. Genetic data sharing carries a spectrum of risks, and it requires oversight systems that protect privacy to the extent that is necessary and appropriate for the endeavor at hand. So, Yaniv gave us a very good rundown of some of the techniques that allow for re-identification, or let's say revealing identities of people or partial identities or characterizations of individuals. And there are concerns about that. There are psychological concerns, there are economic concerns, and there are social concerns related to this. And of course, we know that this is not just something that could impact on the individual as participant or patient, but connected others as well. So then we can take away 3 main points here, I think. Individuals will only contribute their data to the extent that they can trust that their data are sufficiently protected by any given system, including with oversight. That robust protection is needed, but it's a shared responsibility, not just of researchers, not just of the government, but all of us as individuals in society. And that, of course, that this is a public interest concern. This isn't just a concern to make the science work, that we need to solve privacy and data sharing and make them perfectly aligned. But this is, in fact, a public interest that we all have a stake in. This said, I think there are unrealistic expectations about privacy, or certain kinds of concerns or issues that are raised in the privacy context. So you see this classically in the consent or anonymized paradigm. And by that, what I mean is to assume that you can take a consent form to address all privacy concerns, which assumes that that consent form will be read, will be understood, and will be valued. And I think we know that that's a bit of a false impression. And of course, we know all about the risks of anonymization or the problems thereof. But I think also, and this is a bit more controversial, this notion of ownership over genomic information, I think, is equally concerning, but this is perhaps more of a divide between, let's say, North America and Europe, but notions of control and ownership and individual control over one's genome. But I think this can also create a lot of tension between privacy and data sharing when we start to inject notions of individual ownership over data. So what we did in the Privacy and Security Task Team in the Global Alliance was try to spell out this notion of identifiability and a spectrum of risks between anonymous, which means never were identifiable, all the way through fully identifiable data. And part of the problem, of course, is there's a Tower of Babel disagreement between which terms mean which. So you have, for example, de-identified, or is it anonymized? What's pseudonymized is the same as key-coded. So there's a whole plethora of terms, but you can put them into categories, let's say, between least identifiable all the way through most identifiable. I just wanted to briefly highlight, again, the notion that in speaking about privacy, which is not necessarily linked to law, nonetheless, data protection regulation also has an impact on challenging genomic sharing. And so this was just published, as I said, a couple of weeks ago in the official journal, the European Union, the General Data Protection Regulation. The problem, of course, is that there is complete disharmony between regulations depending on the jurisdictions when it comes to data protection, which creates a serious problem of confusion and caution for researchers when it comes to trying to exchange data across jurisdictions. And so there is a general inconsistency that predominates. That said, I think we could say quite clearly that the General Data Protection Regulation, the final version, is a step forward for biomedical research, at least in comparison to the uncertainty over the 1995 directive and in comparison to the 2014 version that was published by the European Parliament, which would have been quite drastic. Okay, so this is kind of setting the scene. Let's turn towards potential policy solutions. There are a variety of tools and initiatives out there that I think are trying to work on this, and we heard one, DNA Land is certainly a brand new and very exciting initiative, but there are several others as well that I think we can turn to. I want to focus one in particular on the Global Alliance for Genomics and Health because I'm the most familiar with this, so if I just can take the last little bit of time to talk about some of the work that's being done. So for those of you who are not familiar, the Global Alliance is an international nonprofit organization founded about 3 years ago now. It's over 1,000 members in over 50 countries. And it's a real kind of dual mission, let's say. One is to kind of establish common frameworks of harmonized approaches to encourage the sharing of genomic and clinical data. But it's also there to try to catalyze initiatives that are already underway to demonstrate success and the value of sharing data. And so this is, it acts as a kind of clearinghouse, let's say. It puts out policies, but also tries to engage professional communities and patients as well, again, to just move this kind of cultural shift forward about the importance of data sharing in a way that is responsible, as I'll get to in a second. So there are currently 4 working groups, security, clinical, data, and regulatory and ethics. And of course, the one that I'm most familiar with is the regulatory and ethics working group. And there are specific task teams within each of these. And they catalyze different projects that are going on right now. The 3 well-known ones are the Beacon Project, the BRCA Exchange Project, which is a pooling of all different open databases containing BRCA variants, and the Matchmaker Exchange, which again is a federated database to try to match phenotypic and genotypic data to encourage knowledge about rare diseases. So I want to talk in particular about the framework for responsible sharing of genomic and health-related data. We use health-related as opposed to clinical to broaden the scope, as a way to try to address some of the privacy concerns on a very broad principles-based level. And what we wanted to do was move from a notion of protection from harm to really promotion of data sharing, but in a responsible way, and harness it using a human rights framework. And we see this in particular from Article 27 in the 1948 Declaration of Human Rights, which speaks about the notion to share in scientific advancement and its benefits, and also for the right of authors of scientific works to be acknowledged for their productions. And this is reflected also in the 1966 International Covenant on Economic, Social, and Cultural Rights, which again takes this language from 1948 and actually puts it into international law, given that 164 countries are now signatories to this international covenant. And then we see most recently, for example, in the Venice Statement, again, talking about this notion of collaboration and sharing of data across borders as a way to facilitate science and actually operationalize this human right. So some colleagues and I, a couple of years ago, said, let's take this notion of human rights and try to build it into a framework that promotes the responsible sharing of genomic and clinical data. And so what we did over the course of about a year was, through an iterative process as policy drafting happens, go through several draft form, put it out for public comment, take it back, revise, put it out for public comment, and then eventually around September in 2014, the framework was finalized with multiple partners from around the world who helped it put together. And it's now been translated into 12 languages, and I think more are in the process of being written. It's based on 4 foundational principles: respecting individuals, families, and communities, advancing research and scientific knowledge, promoting health, well-being, and the fair distribution of benefits, and fostering trust, integrity, and reciprocity. And these are very high-level principles upon which core elements can be built. But we felt it was absolutely important to have these foundational principles form the basis of a framework, and to not try to define what we mean by them, because inevitably that would just open it up to contention, but to have these basic high-level principles form the basis for our work. And then we could start to build in common core elements for responsible data sharing, and within each of these 10 core elements have more specification. What we've now done in the last year is building on the framework, which again is a very high-level principles-based document, draft a consent policy and accountability policy, a privacy and security policy, and also some consent clauses that really address international data sharing issues. So the one that we worked on within the last year, it came out in May a year ago, was a privacy and security policy, distinguishing privacy from security, trying to define what we mean by privacy, and taking on board the literature and the findings from people like Yaniv to say how exactly can we work with what we know about the limits of anonymization, the concerns about data sharing, without trying to say let's forget about privacy. So we worked on this, also building in different kinds of measures to protect the security of data as well. So we used the notion of privacy best practices, again, taking, in this case, 13 best practices and spelling out what we meant to by each of these, and then taking different measures, physical, organizational, and technical, addressing the security aspects as well. Just to briefly highlight that we've also developed a consent policy, as I mentioned, which also builds in notions of privacy, and an accountability policy, which asks the questions, why are you not sharing if it was consented? And so it frames the question in a different sort of way, and then addresses categories of abuse and calling for appropriate responses in cases of misuse. We've also now developed a data sharing lexicon, again, getting back to this notion that different terms are defined in different ways, and it creates a complete discord and confusion about what we mean by different things. So again, this notion of pseudonymized versus key-coded, etc. So this was put out a couple months ago just to promote a kind of consistency in data sharing. What we're now working on is this notion of registered access, which is a kind of in-between stage. So the classic kind of binary in data sharing systems, of course, is between open and controlled. But we know all the problems about data access committees and the kind of bureaucracy that's created, and how what was supposed to be a kind of not so much bureaucratic initiative has turned into a lot of red tape and problems in trying to get access to controlled data. So we're thinking about this kind of in-between, this notion of registered access, which is based on this what we call AAA approach of authentication, attestation, and authorization. And having built policies around this registered access notion, put it into a project. So this, I think, will be seen in the next year. Just to highlight a couple other issues that have come up. So we have now data use categories and requirements, or this notion of consent codes, again, to promote consistency across systems. So this was published in PLOS Genetics in the last couple of months. Defining what we mean by data safe haven. What are the elements that constitute a data safe haven? And then this notion of ethics review equivalency. So this is another key project that we've been working on, particularly within one task team in the ethics, in the regulatory and ethics working group. We know, of course, the problem for international data sharing initiatives having to navigate ethics review at each local site, unless you're luckily enough based in a country where one ethics opinion rules the roost, as is the case in the UK. And this creates a lot of problems of duplication and inconsistency. So we're also, again, trying to think about how we can work around some of these bureaucratic problems and to try to promote a more efficient but still ethically robust way of encouraging the sharing of data by trying to create this notion of mutual recognition between ethics review. So just to conclude, I hope what we can acknowledge is that data sharing and privacy are not zero-sum, that they can and must work together. I think we could have a debate about whether our conceptions of privacy are fit for purpose in the 21st century. But I think the important thing that we're acknowledging is this pivot towards good data governance. And that said, I think there's a lot of things that we could still do, including the importance of engaging patients and participants to acknowledge and get a sense for what they think the importance is of privacy and data sharing. Developing robust governance and data access mechanisms that can include authorization mechanisms, registered access, et cetera, but also thinking about accountability and holding data users accountable for the actions they undertake with data, whether that could be misuse, abuse, and so on. So I think that's it. Thanks very much.
Thank you. Are there any questions? Annelien.
Thank you. Thank you, Edward, for this excellent talk. I was wondering, in the European Union, there seems to be a shift from the right to privacy as a fundamental right to the right to data protection. So I was wondering, as a new fundamental right, so I was wondering, do you think it's a favorable development, the shift towards data protection? And what do you see, what is the relation between data protection and privacy?
Yeah, so in the Charter of Fundamental Rights of the European Union, one of the fundamental rights is the right to data protection. This is a right that doesn't exist in other jurisdictions. Other jurisdictions might have a quasi-notion of a right to privacy. In the US Constitution, it's under a penumbra, let's say, in Article 4, I think, of the Constitution, particularly in the context of search and seizure in the criminal context. The two are distinguishable because privacy is much broader, I think, than data protection. Privacy can encompass notions of, again, the physical person, decisional privacy, governmental interference, whereas data protection, and a right to data protection, really focuses, I think, on the kind of administrative data-driven elements as it relates to information. So the two are distinguishable, rightfully so, I think, in European law. And I would not be surprised that if other jurisdictions take up this notion of a fundamental right to data protection as well, but the two are distinguishable.
Yes.
Yes, hello. My name is Sigrid Thorsen. I'm from the Norwegian Biotechnology Advisory Board. So now you have this framework that seems pretty thought out and well thought through. How do you see that being implemented in the EU or globally? Or so, what is the bottleneck?
Well, the bottlenecks are many, and many are beyond the power of a nonprofit organization to solve. And so one example would be the regulatory bottlenecks. What we can do is work with governmental authorities to try to encourage greater harmonization of regulation, which is a significant bottleneck. But what we have been doing, and what I think we can do, is take more bottom-up initiatives. It's very hard for us to do anything top-down, nor do I think that's within our remits, nor would we want to. So what we've seen, for example, in the framework are data sharing initiatives or research consortia, which in their consent forms acknowledge that we will conduct ourselves in accordance with the framework for responsible sharing. And that, I think, is what we can do at this early stage, given that it's only been a year and a half since it came out, just to encourage a conversation. And by convening different stakeholders together, including ideally with regulatory bodies, we can start to have a discussion which says, we can make privacy and data sharing work together. They're not irreconcilable. It's not zero-sum. Here's our initiatives that we are undertaking with the force of 1,000 individuals and organizations behind us with over 50 countries. Let's try to have regulatory solutions as well, so we can have the top-down in addition to our bottom-up.
Any other questions? We have some time left. If anybody has a question for Yaniv, then we can also ask that. No? Okay, I think at the beginning of this session, I asked you what thrills you in your job. And you said, well, this is such a quickly changing field in law, and that's what enthuses me. And your presentation was a great reflection of that enthusiasm. I think you've done a really thorough job in incorporating so many different aspects into a new notion. So it's I've got a lot of respect for that. Thank you very much for your presentation.
Thank you.
Thank you, everybody.
Thank you.